Ladies and gentlemen, imagine there is a magical garden in the middle of your city, hidden and forgotten by everyone. Nobody looks after that garden or claims it as their own. One day, you and your friends find it, and amazed by its beauty, you make it your secret place to hang out or your secret playground about which nobody else knows. So, what do you call such a garden or a piece of land that nobody occupies or claims as their own? It is called Terra Nullius, a Latin term that literally means the land of no one. Terra Nullius is an old concept that has been used to describe places like Australia. You would be surprised to know that when Captain James Cook came to the Australian shores in the year 1770, he declared a part of the Australian continent to be British territory, as according to him, he and his crew were the first ones to occupy the Australian continent, and before them, there was no kingdom or ruler or state that occupied Australia. They called it as the legal concept of Terra Nullius, and on the basis of this legal principle, Britain continued its colonization in Australia for more than a century. Accordingly, international law recognizes territory over which there is no sovereign or ruler as terra nullius. The method of acquiring this terra nullius in international law is called as occupation. There are four important points that you need to know in this regard. First, the occupation of terra nullius must be by a state and not by private individuals. Second, the control of territory or terra nullius must be effective and permanent. It should not just be on paper, or it should not just be a photo op. Third, the occupied territory should not be res communis. Res communis is the opposite of terra nullius, and it means something that belongs to everyone. In international law, it is an area or territory that is not subject to any legal title or ownership. High seas, Antarctica, and outer space are some of the examples of res communis. Basically, anything that is the common heritage of the entire mankind is considered as res communis. Fourth, the terra nullius that is occupied should be uninhabited. That is to say, it should not be occupied by any indigenous communities or tribes. This was also held in the famous Western Sahara case. Now imagine there is a country A. It was occupying an island till the year 1950. However, after 1950, country A abandoned its control over that island. 73 years later, country B goes to that island and occupies it on the ground that country A had abandoned its control a long time ago. So the question is, can country B occupy that territory now? Yes, it is settled in international law that abandonment of territory might render an otherwise occupied territory as terra nullius. Lastly, you need to know that if any country wants to establish its occupation or sovereignty or control over a territory, it does not need to prove its occupation in absolute terms. That is to say, there are no watertight rules that govern the concept of terra nullius. That country simply needs to establish a better title or a better case before the courts against its opponents to prove its occupation. And while deciding such cases, the international courts generally look into the history, geography, and the responses or claims of the international community with respect to that territory. So, that is all about terra nullius. Let me know in the comments section whether you liked this episode or not. See you next time.